the matter of Smith and Pimlico Plumbers Ltd.
Yes, Mr. Ford.
My ladies, I appear on behalf of the appellant with Mr. Queen's Counsel and Mr. Stevenson, and to my right is Mr. Jeans, Queen's Counsel, and Mr. Smith. My ladies, so often you get to say that in the Court of Appeal, can I just check you have all the documents? There should be 2 authorities bundles.
Yes.
A core bundle and a supplementary bundle.
I've forgotten my supplementary bundle. Yeah, well, I'm very glad you checked, because I think I've got it. My supplementary bundle doesn't seem to have... Clark's gone. Could you ask Sean to come back, please?
Shall I carry on, my
Yes,
lady?
do.
And in addition, we've handed up 2 additional documents. The first is Sash and King ECJ in the IRLR, because the ICR version doesn't have Advocate General Tanchev in it. And secondly, we've handed up our proposed amendment of Regulation 14 to give effect to what we say are the principles in King.
That's very helpful. Thank you very much. If I, in exchange, can say to all of you that we've each had an opportunity of reading extensively into the papers in this matter. I think we've all read all the essential documents as well as the judgments and the skeleton arguments. I don't know, I presume you've decided between you some timings, but if I can just indicate, for our part, given the amount of reading we've done, we regard 2 days as a very generous estimate.
Well, my lady, maybe our mistake. We originally asked for 3.
Oh,
I will try and be very brief on the facts and the background, given my lady's indication.
Well, we really are familiar with them.
Well,
I think each of us have probably spent the best part of a day each pre-reading in this.
I'm grateful. So perhaps if you can give me a nudge if I'm going over stuff.
Well, my ladies, who of course have the considerable expertise that I don't have in this matter, will be probably key nudges.
Yes. Thank you, my lady.
Yes, now if I can just... Sean.
Yeah.
Yes. Just check, would you? Yeah. Thank you. I don't think we need delay.
Thank you.
Thank you very much. Yes.
And if I will refer to the parties as claimant and respondent to avoid confusion. And of course, our focus is going to be on the correctness of the tribunal decision rather than the EAT's decision.
Yes.
Now, the grounds of appeal, if I can just explain the structure of how we intend to deal with the appeal on our side. The grounds of appeal are at 13. This is a composite document with the new grounds C and B at the end, and grounds A and B with the underlining granted by Lord Justice Bean in relation to A and B. Now, I am going to deal with ground C, firstly. That's whether or not the ET erred in rejecting a claim for untaken leave based on King, if I can call it that. Secondly, I'm going to deal with ground B, the pleading point, which is 7 and 7A. Then I'm going to deal with ground D, which is the series of deductions issue in relation to the conflict between Bear Scotland and Agnew.
Sorry, you missed out A, didn't you, in that?
Mr. Glynn will then deal with A.
At the end?
Yes.
Okay.
So Mr. Glynn will then deal with A. And he will also deal with effectiveness. We are not pursuing the point on equivalence.
Yes.
So in light of my lady's indication, I don't propose to say go to any of the documents in the factual background unless my lady wishes me
No, I think we're clear on that, and we'll have been to those documents in any event.
Can I then pick it up with the tribunal judgment itself, which is at 141? And once again, I know my ladies will be familiar with this, but just to explain exactly how matters proceeded below, you can see in paragraph 1 that the tribunal took the course of deciding to reach a decision on what it termed jurisdictional issues. Now, it may be relevant to know precisely what happened, because in fact the claimant never gave sworn testimony. What happened was the respondent's counsel indicated he wouldn't cross-examine, and that the tribunal should decide what he called the jurisdictional points first, saying that if the respondent was right, that was the end of the claim. But if the respondent lost on any of those, then it would be necessary to consider the exact dates when the claimant took leave, and so on and so forth. So the tribunal never actually got to that second stage.
So, but to the extent that it proceeded on the basis of facts, it would have had to take the claimant's case at its highest.
Yes, well, that's how we would put it, certainly. It's akin to a strikeout.
Yeah.
But it meant it never actually explored the exact dates when the claimant did or didn't take leave. So when at paragraphs 6 and following the tribunal set out its relevant findings of fact, it needs to be seen in that context. Although it did, curiously enough, find as a fact that the last period of leave the claimant had taken was the period between 18th December and 4th of January. And so the structure of the tribunal decision, which of course we'll explore under each of the individual grounds, is at paragraph 17. There was no agreed list of issues. There were various lists floating around on both sides, but there was no agreed list. But the tribunal, having agreed to the respondent's proposed course of action, decided it would deal first with any jurisdictional questions. And the tribunal, you can see at the bottom of 17, E.J. Morton herself decided that the issues I needed to determine were as follows. So she decided the relevant issues for the this jurisdictional preliminary hearing. Now, so in relation to each of them, the structure is that each of those issues then feeds its way across into the subsequent decision. And we'll explore them more in relation to each of the grounds. And given the indication that my ladies have read extensively into the background, I won't say anything about the findings in relation to each of those specific items, because you're familiar with those. And nor will I go to the reconsideration judgment, which, as you know, the tribunal declined to reconsider its finding that the last period of leave the claimant took ended on the 4th of January. And
Mr. Ford, I should just say that in giving that indication, obviously I'm not trying to drive a scythe your way through your submissions. You must, of course, deal with matters to the extent you feel necessary for us to have a proper understanding of your case.
And the EAT dismissed the appeal, and for my lady's notes, it's now reported at 2021 ICR 1194.
Sorry, the page number?
1194. Perhaps just before I go to the first ground I'm dealing with, it is worth looking at one passage in the claimant's witness statement, which is in the supplementary bundle.
Two, three, one.
231. And one sees, first of all, at 234 at 14, the claimant said he was dismissed on the 3rd of May. So that set the relevant date for the purpose of that was the termination, if you like, which therefore triggered a potential obligation under Regulation 14. He set out details of, well, an outline of the times he took holiday at 18 to 22. Said at 23, I've not kept a specific record of my leave taken each year and have to reconstruct events using journey reports and pay slips in the bundle. And that reconstruction was what paragraph 40 was then based upon. Now, paragraph 40 wasn't self-evident to me when I first read it. So just to explain how this table works, on the left-hand column you have tax years. So those are years ending, because that's how the pay slips work. They started on tax period 1 and continued. It follows they don't correspond with the leave year, because the relevant leave year would have begun on the 25th of August each year. And you can see under leave, there's a reference to missing pay slips. And you can see the claimant has said the leave he took in the 5th column. And in no case had he actually taken, on his case, the full entitlement either of Euro leave, being 4 weeks, or domestic plus Euro leave, being 5.6 weeks. As regards the final year, 2011 to 12, that of course only involves a period of around a month, because it's from the 3rd of April, well, it is exactly a month, from the 3rd of April until the 3rd of May. And there, although it says 3 weeks leave, in fact, that is inconsistent with the tribunal's finding. Whether it should have done that is neither here nor there, because there's no appeal against that. That's because the tribunal found he did not take any leave after 1st of January 2011. 4th of January. So, in a sense, a line can be put through 3 weeks leave there, based on the tribunal's findings. And the claimant went on to confirm at 41, it's likely that leave taken coincides with missing pay slips. This is at the bottom of paragraph 41, as I did not get paid when I took leave. So that was his attempt to reconstruct what had happened based on the pay slips. And the only other document I should or the only other two documents I should show you is the pleading.
So just before you do, I'm so sorry, Mr. Ford.
Yes.
So Mr. Smith said that that statement would go in unchallenged.
Yes.
But nonetheless, the tribunal made findings in contradiction of it.
Yes. Now, whether or not that should have been challenged below is neither here nor there. I accept we haven't got a ground to appeal on that.
Right. So
nevertheless, it sets the context, because one of our submissions will be, having said those 3 weeks leave are out, as it were, we then say, well, that's shouted out on the basis of that finding that there was then a potential claim under Regulation 14. Because once they'd said, well, you didn't take leave in that period.
well, but that was the year before.
Well, the termination year would run from August 2010 until May
So it
2011. So the 3 weeks goes.
Yeah.
You were then left with 3 weeks having been taken from April 2010 to May 2011 on the table. And we've done the calculation in a footnote in our skeleton to show that even assuming all of that leave took place in the final leave year, it meant there was a Reg 14 payment potentially due. Right. So that even taking the assumptions most unfavourable to the claimant, which the tribunal wasn't entitled to anyway, but even making assumptions most unfavourable to the claimant, there was a potential liability for Regulation 14.
A 1 week liability. Or less.
Well, it would be,
or more.
If you turn to our skeleton, my lady, you can see the actual calculation is, it's at page 39 of the bundle. And it's at footnote 7. So the most he could have taken was 3 weeks in the period 25th of August to May 2011. When you do the formula in Regulation 14, that amounts to 251/365 equals 3.85 weeks. Therefore, even taking the most unfavourable case to him, he had 0.85 a week due. But of course, had the tribunal properly gone on to explore it fully, it may have found that he took less leave in that period, because to the extent he took leave after August, it would therefore, he may have had less. But in any event, the 3.85 figure is uncontroversial. That follows as a matter of law. The only issue to explore is how much leave he in fact took. So I hope that sets the scene as to why there was, on the facts, a potential Regulation 14 claim. So the domestic rules.
You said you were going to some other documents before I interrupted.
I'm very grateful, my lady. Yes, just the claim form itself. The claim form itself is at 170. At 172, you can see the claimant tick the holiday pay box. He then said at paragraph 5, 177, I took annual leave, but R1, that was at the time when there were 2 respondents, did not pay holidays under WTR. So he doesn't say how much leave he took, but he does say I took annual leave. And then at 21, he says, this is at page 182, I was denied paid holidays from the outset or at a later stage in my contract. And we'd say that the term denial can encompass both being given no holiday and or not being paid in respect of it. For completeness, at 27, there's the bank holiday point at the end of that, which the tribunal found effectively wasn't leave. And at 37, under the unlawful deduction from wages heading, as an employee or worker, R1 failed to allow, which we again would say can embrace not paying or not giving, my entitlement to paid holidays from the outset of my employment or at a later stage. This was a continuous failing connected to each annual leave year up to the date of termination, 3rd of May 2011. And again, unpaid holiday listed under the remedies at 43. And the respondent's response, which I know you've read now, is at page 186 and following. And you can see at 10, they page 192, they denied the claimant was an employee and a worker of Pimlico. At 23.1, 197, they said operatives do not undertake any work for substantial parts of the year. They simply inform Pimlico that from a certain date they will not be available. So it seems their indication was that people didn't take leave, they just didn't work for various parts of the year. And then at 38.5, the page 202, the denial of the working time claim, they denied the claimant had any entitlement to paid holiday under Regulation 13. Denied the claimant ever requested paid annual leave, and denied he was ever denied paid annual leave. Whatever that means. I can only cope with one negative in the sentence. There's nothing to suggest that he actually took annual leave. They didn't plead anything to the effect that he took annual leave. As for the statutory framework, in light of my Lady King's indication, I will just say a little about these, much as I know I'm teaching some people here to suck eggs. They begin at divider 5 of the authorities bundle. Well, perhaps first divider 8, article 7. So we've got it in our minds at 90. A few very sparse words about every worker's entitled to paid annual leave of at least 4 weeks, which I don't think anyone would have ever guessed has led to so many principles from the Court of Justice and have kept some of us in employment for a long time. And the right to a minimum period of paid annual leave. Sorry, not a right to a payment on termination, but a provision by which you can only have an allowance in lieu when employment's terminated. The reasoning being that otherwise allowances in lieu will prompt people not to take leave. The charter I won't take you to, but is in the bundle at tab 7. That is now horizontally...
So just before we leave Article 7, then, for us simple souls, the key wording might be regarded as paid annual leave.
Yes. Well, I'm always scared when a court starts talking about simple souls. Yes, the key words are paid annual leave, and then the Court of Justice has read many principles on top of that.
Yes, which I've been dipping into.
All of which, I think I'm correct on this, the national courts have managed to give effect to via leasing. I can't think of any case where the national courts haven't been able to achieve the result of Article 7 via leasing.
Sorry, we're moving on to...
But in a sense, that doesn't matter. Just to give you the reference to the Charter at tab 7, because now we know from Shimizu and Bauer, the two cases handed down as a trilogy with Kroiziger on the 6th of November 2018, all Grand Chamber cases, the Charter has horizontal and direct effect. And none of this is affected by Brexit, because we have the provisions of the 2018 Act.
And the president of the EAT dealt with it, and neither side appears to challenge his approach.
I can't help pointing it out. He is wrong on one respect. He said it's exit day,
yes,
which is the relevant date. That's wrong. It's actually IP completion day, being 31st of December 2012. So the Charter had effect up until that date, and by means of the transitional provisions, proceedings begun before that date you can still rely on the Charter directly. And secondly, the leasing obligation is preserved by means of Section 5, both before and after IP completion day. So both conduits are preserved. And then the domestic regime only, in passing really, at divider.
Sorry, what was the date for the Charter, the direct effect of the Charter for proceedings commenced before?
Proceedings commenced before IP completion day, which is 31st of December 2020. This is in our skeleton, my lady.
Thank you.
And although Section 5 of the 2018 Act is a little opaque, the explanatory notes confirm that that's the conduit for leasing, where you've probably dealt with it. Yeah. So there we are. And then, of course, there's the domestic regime at divider 5. Just to deal with this quickly, first of all, Regulation 13 at page 65. That's the basic entitlement to 4 weeks leave, implementing the right under the directive. And Regulation 13.3 little Roman 2, that's the date which fixes when the leave year begins in the absence of a contract. So that meant in the claimant's case, it was the date he commenced employment. That was 25th of August each year. And the prohibition on carryover in 13.9, mirroring the directive, leave to which a worker is entitled may be taken in instalments, but it may only be taken in the leave year in respect of which it is due. And that is the domestic provision, which has been consistently overwritten to give effect to rights of carryover under EU law. Firstly, in relation to sick workers, see Lana. Subsequently, in relation to others, see King. And there's no dispute between us that you can carry over, where necessary to comply with EU law. And in the alternative, that provision would, of course, fall to be disapplied under the horizontal effect of the Charter. 13A over the page at 67, that's the additional domestic leave, 1.8 weeks, 1.6 weeks, forgive me. But you can see under 13.4, again, the leave year, fortunately for everyone, begins on the same dates as does the 4 weeks leave. We then have the formula for compensation in Regulation 14, which is a pro rata calculation, where you have a worker's employment is terminated during the course of his leave year. That's 14.1a. So that applies here to Mr. Smith. And the proportion he is taken of the leave to which he is entitled differs from the proportion of the leave year which has expired. So it's a pro rata calculation. And the relevant calculation is done at Regulation 3, where you have A times B minus C. A is the period of leave to which the worker is entitled. Well, that will be 5.6 weeks in the case of Mr. Smith. B is the proportion of the leave year which has expired. I've given you the figures for that. It was, I think, 251,356. And then you deduct the amount actually taken. The right to pay at 74. You're entitled to be paid at the rate of a week's pay. That's the domestic rules that apply in redundancy, unfair dismissal, and so on for each week of leave. That's during employment. And the same figure applies for the purpose of the payment under Regulation 14. And then the remedies, which Mr. Glynn will refer to as the bifurcation. So under the domestic regime, you have at page 76 two distinct remedial provisions. First of all, 31A, a refusal to permit the exercise of the right. So that can be, for example, where an employer refuses to let you take leave. And secondly, under 31B, where the employer has failed to pay him the whole of any part of amount due to him under Regulation 14.2, termination, or 16 on employment, during employment. And they translate as well into different limitation periods, because under 32A, in the case of a refusal, it's the period of 3 months is counted from the date when the exercise of the right should have been permitted. So it'd be the date when you say, I wanted to take leave, but your employer said you can't. But in the case of a payment, it's the date when the payment should have been made. So it will typically be the first wage slip following the time. So, my ladies, ground C. And this is where we say in a nutshell that the claimant fell squarely within even the narrowest reading of King. His uncontested evidence was that he had not taken leave, every leave, his full Euro leave entitlement in every leave year. That leave was always unpaid. Therefore, in accordance with King, Kroiziger and Shimizu, it carried forward until termination. The tribunal wrongly assumed, however, that because he didn't plead or say he was ever refused leave, the King principle didn't bite. Wrong, wrong, wrong. The King principle, as amplified in Kroiziger, is that the employer has to show, the burden is on the employer to show it actively encouraged the employee to take the worker to take leave and informed him that the leave would be lost if he didn't. There is no need of a request by the worker, no need of a positive refusal by the employer. And my ladies, if I can just trace the evolution of the principle through historically, we begin with King in the EAT, which I know my lady Simler decided, which is at divider 34.
So are we now on ground A? I'm a little confused.
No, ground C. This is the argument that he had a claim for untaken leave based on.
Okay, I'm sorry.
Untaken.
Untaken leave.
Yeah, I apologise, my lady.
No, it's my fault.
So at this stage, I'm restricting our argument to untaken leave.
Yeah.
We can see a very distinguished EAT at paragraph 1.
Flattery will get you everywhere.
Has to be a bit more subtle than that to work, I think. But anyway, paragraph 1, you can see Mr. King was to some extent in a similar position to Mr. Smith, in that he was a commission-only salesman, that they denied he was a worker. The relevant, you can see over at 6, Mr. King's schedule of when he took leave. So in common with Mr. Smith, he didn't take leave he didn't take all of his Euro leave in pretty much every year. And at 7, the tribunal actually listed the weeks that he didn't take. So in some years he took all of his leave. You can see between 2005 and 2007. Now there were 3 claims before the. I'm sure you remember it very well. There were 3 claims before the EAT. Holiday pay 1 was for this is at paragraph 10. Holiday pay 1, that was a Reg 14 payment under domestic law. Holiday pay 2 was leave taken and unpaid during employment. The tribunal had awarded sums for both of those, but they weren't subject to the appeal. So the appeal, I'm looking at my lady Simler because I know she dealt with it, was concerned with holiday pay 3.
Only.
That was untaken leave, just as I'm submitting now. And the relevant decision of the EAT is really at paragraphs 32 and following. Which, if it's acceptable, I won't read out, but you can see there that the EAT found there was no restriction on the claimant's ability to take annual leave. Reading on a bit, there is no evidence that he was ever prevented from exercising the right. Rather, despite having the opportunity to do so, he chose not to. Nor indeed is there any finding he could not afford to do so. And in that light, the EAT concluded at 34, it was not right to follow Lana, which had allowed carryover by sick workers, and say he was permitted to carry over the leave. Rather, his claim would have had to be a refusal claim. That's at 37 and 38, which I won't take my ladies too further. So the EAT was saying, in these circumstances, your only claim is a refusal claim. Now, if matters had stood there, we wouldn't be here. But then what happened was it then went to the Court of Appeal. Don't think we have the decision making the reference.
Was there a decision?
I've not seen one, no. I think they just...
It settled before it came back.
No, I mean the decision making the reference.
Leading to the reference. That we've got the questions asked on the reference, but there's no judgment as there
I
is in
haven't
some
found one.
cases.
I don't think any of us
No,
have found
fine.
one. So off it went to the Court of Justice. Here the toadying can stop, like many before her, the EAT was wrong. Well, there's no shame in that. I think the number of times the Court of Appeal has been told they got holiday pay wrong by the anyway, so the Court of off it went to the Court of Justice. And the Court of Justice summarises the facts at 14 to 17.
We're at tab 40 now, aren't we?
Yes, I apologise, 737.
Yes.
We get the usual mantra. Well, the questions are at 24. In particular, 1 and 2. I won't take you too further. And then the analysis of the first question at 31. Does Article 7 preclude the worker having to take his leave first before establishing whether he has a right to be paid in respect of it? And we get the usual mantra about it's a particularly important social right at 32 and following. But the key to the decision is 36 to 40. In answer to the first question, the Court of Justice first refers to the worker being entitled to benefit from remuneration, which Mr. Glynn will come back to. 38, they talk about a worker being faced with uncertainty about leave. And then critically at 39, similarly, this is where a worker isn't being paid in respect of leave. Such circumstances are liable to dissuade. Now, I place emphasis on liable from taking his annual leave. In that regard, it must be noted that any practice or omission of an employer that may potentially deter, again, emphasis added, a worker from taking his annual leave is equally incompatible with the purpose of the right to paid annual leave. And 40, for good measure, contrary to the United Kingdom's written observations, observance of the right to paid annual leave cannot depend on a factual assessment of the worker's financial situation, which I think is what you've done in the AT. You'd said he could afford. No, it's because it's a question based on potential deterrence, not individual deterrence. And for what it's worth, at 39, you'll notice they cited Locke at paragraph 23. Just for my ladies' notes, that's at tab 32599, where again the Court of Justice referred to that a reduction in remuneration is liable to deter a worker from taking leave. So that's Locke 23, which is cited there. And Locke 23 also cited British Airways, which, at paragraph 21, Williams and British Airways, which is at tab 27. I won't take you to it. But as Mr. Jeans would remember, because he was for British Airways, one of British Airways' arguments in the Court of Justice was that a reduction in remuneration wasn't in breach of the directive because it didn't actually stop pilots taking leave. So they weren't individually deterred. And you can see that referred to in the opinion of Advocate General Trustenjak in her opinion at paragraph 24, page 421.
In this case, or in BA and
In BA and Williams.
Right. Can you
So
just give me
can
the reference
see
again?
At Advocate General Trosteniak at 24, page 421, and similarly the Court of Justice at 21, 446. So you see a consistent thread throughout all this case law, potential liable to deter, not actual individual deterrence. And in fact, in BA, there was no evidence any pilot had ever not taken his annual leave. And Advocate General Tanchev at 92, this is in the IRLRs we've just handed up.
Sorry, where have we gone to now? I'm sorry,
We're now in
I turned to British Airways, so I'm distracted. No, I distracted myself by reading the bit of British Airways. Where are we now?
It's my fault. It's in the IRLRs of King, Sash Windows and King, the one we just handed up with the Advocate General.
Fine. Thank you. Shall we tuck this in at 40?
Where Advocate General Tanchev says at 91, the court has held incompatible with Article 7.1 of the directive, this is paragraph 91, practices that create a serious risk the worker will not take his leave. And the footnote there is again citing Williams. And then goes on to say, 92, it would seem to be inarguable that a worker will be deterred from exercising his right to paid annual leave if he is first required to take it without payment at all. And goes on to refer to that as being contrary to effet utile. So, back to the Court of Justice. The Court of Justice, having reached that conclusion on the first question, then went on to the second and fifth questions at paragraphs 48 and following. To deal with whether or not that leave could be carried over and accumulated. And to cut a long short story short, by reason of the factors that it listed at 56 and following, it concluded that Mr. King was in an analogous position to sick workers, had regard to various factors at 58 and following, which all of which meant that he carried over his leave. So he carried over leave, untaken leave, and accumulated it until termination. And you can see the answers to the question at 65. Must be interpreted, Article 7 of the Directive must be interpreted as precluding national provisions or practices that prevent a worker from carrying over and, where appropriate, accumulating until termination of his employment, paid annual leave rights exercised in respect of several consecutive periods because his employer refused to remunerate that leave. And we say we are on all fours with King. Critically, it is not necessary for the worker to show he sought to take and was refused the right to take annual leave. And if you want to see why that is even clearer now, you need to look at Kroiziger. And it's really enforced by two decisions, as I say, both Grand Chamber, both handed down on the 6th of November 2018, both Advocate General Bull and Kroiziger is at divider 45, thank you. So Kroiziger is at 45. Just to take very briefly the facts, they're in paragraphs 9 to 11 of the Court of Justice. You can see Mr. Kroiziger was a Rex referenda, excuse my pronunciation, with the land of Berlin. Oh, sorry, paragraph 9, page 901. He didn't take paid annual leave between the 1st of January 2010 and the date his employment ended, which was the 28th of May 2010, and he asked for a payment in lieu, so this is a payment in lieu claim. And the National Court refused. I can summarise, it's really dealt with at paragraph 11, but the National Court refused on the basis that he wasn't prevented from taking leave in circumstances beyond his control. So this is a case where he's actually paid for his annual leave. He's fully paid.
Well, he would have been if he'd taken it.
He would have been if he'd taken it, yes. So there's no disincentive for him not taking leave. And nor was there any evidence of a refusal. So he is Mr. King or Mr. Smith with bells on. This is someone who, if they take leave, gets fully paid for it, but just hasn't taken it, hasn't taken all their entitlement. And perhaps surprisingly to many, the Court of Justice decided he could still have his payment in lieu. And it begins at paragraph 32, page 905. By citing the cases allowing sick workers to carry over, Stringer, and citing Sash King. So those are the cases it cites. It then says at paragraph 35, the referring court is therefore essentially asking whether in light of the case of the court cited at 31. Now that must be a typo. Yeah. That must mean 32. On the date on which the employment relationship at issue in the main proceedings was terminated, Mr. Kroiziger was still entitled to paid annual leave capable of being converted into an allowance in lieu. Now, the reason I'm referring to King is that this is a development of the principles in King. So it's an evolution of the principles. And the court frames the relevant question, if you like, at 42, that you can lose the right to annual leave at the end of a leave year.
Sorry, before you go to that, 36 makes it clear that this is about the interpretation of 7.1, not,
yes.
Not first and foremost the interpretation of 7.2.
No, but it's still about a payment in lieu on termination.
Yes.
Just as was Shimizu, because in both cases the employment relationship had ended.
Yes, but
so
it's quite important that they're talking about it being 7.1, isn't it? Because that's about a composite right to paid leave.
Yes.
Sorry, yeah.
And the court frames the question for itself at 42, or rather the relevant test. You can lose the right to annual leave at the end of the leave year, provided, however, that the worker who's lost his right to paid annual leave has actually had the opportunity to exercise the right conferred on him by the directive. So you actually have had to have had the right conferred on you. At paragraph 49, they again echo exactly what I've been submitting in relation to King and Williams. that incentives not to take leave or encourage employees not to do so are incompatible with the objectives of Article 7. That's 49. And these important words, thus any practice or omission of an employer that may potentially deter a worker from taking his annual leave is equally incompatible with the purpose of the right to paid annual leave. Potentially deter. The same theme, potential, not actual deterrence. And you ask there, well, what could be a greater deterrence than telling someone if you take annual leave you're going to get no pay? Hard to think of a more powerful deterrent. But then this is the critical next step. In those circumstances, it is important to avoid a situation in which the burden of ensuring that the right to paid annual leave is actually exercised rests fully on the worker. And while the employer may then argue no application was submitted. And thus at 51 we have the switch in the burden. The fact remains that employers must ensure that workers are given the opportunity to exercise such a right. And then at 52, they explain how the burden works. Now, before we go to 52, if you can just keep a thumb in there and look at what Advocate General Bowe said, because they specifically approve paragraphs 43 to 45 of Bowe. You keep a finger in there and go back to Advocate General Bowe at 43 to 44. Now, I won't take you through all of this, but I'd ask the court, if possible, to read it later. But you can see at the end of 44, after footnote 25, which again is referring to King, Advocate General Bowe says it follows from the foregoing that the fact that a worker did not request to exercise his right to paid annual leave during the reference period cannot in itself entail the loss of that right. And corresponding the loss to an allowance in lieu of untaken paid annual leave at the end of employment relationship. According to the court's case law, moreover, whether or not a worker made request for paid annual leave seems to be irrelevant. So requests are irrelevant. And then back to 52. That's where they impose the burden on the employer. The employer has to ensure, and I'm picking up 4 lines down, specifically and transparently that the worker is actually given the opportunity to take paid annual leave to which he is entitled by encouraging him, formally if need be, to do so while informing him accurately in good time so as to ensure that that leave is still capable of procuring the person concerned the rest and relaxation to which it is supposed to contribute, that if he does not take it, it will be lost at the end of the reference period or authorised carry-over period. So the employer must show it encouraged the worker to take annual leave, and it must show it informed him that if he doesn't take it, the right will be lost. And making it quite clear at 53, the burden of proof in that respect is on the employer. Should the employer not be able to show that it has exercised all due diligence in order to enable the worker actually to take the paid annual leave to which he is entitled, it must be held that the loss of the right to such leave, and in the event of the termination of the employment relationship, the corresponding absence of a payment of an allowance in lieu not taken, constitutes a failure to have regard, respectively, to Articles 7.1 and 7.2. And at 55, back to the liable to encourage the worker from taking his leave point. So the critical point from Kroiziger is you only lose the right if the employer satisfies the relevant conditions set out in paragraph 52 and the burden of proof is on it. And for good measure, the Court of Justice repeats exactly the same as Shimizu. I'll only go to it very quickly because it's almost word for word of Kroiziger. Shimizu is in divider 43. And just to give the court the reference to the facts, they're at paragraphs 10 to 12 at page 815.
It's a different Advocate General.
Oh, I thought it was Bow again.
Oh, it is. You're right. Sorry, I beg your pardon. It is. Beg your pardon.
Yes, I'm sure it's Bow because he keeps,
it is.
he always cites my friend Professor Bogg. So I always get told repeatedly that Bow used to cite him.
So facts 10
And
to
you can
12.
see 10 to 11, 10 to 12. Again, this is someone given paid leave, no deterrence. And he was actually asking to take, if you look at paragraph 12, not just leave in the leave year and termination, but even leave in previous years. Invited to take it. Yeah, he was even invited to take it. And he didn't take it, but they still didn't meet the burden of proof. So you can see how strict is the obligation imposed on the employer. And if I can just give you the references because they duplicate Kroiziger. It's paragraphs 35, 42 and 45 to 48 and the answer at 61. Same as Kroiziger. And secondly, again, if I can just give my ladies the reference, at paragraphs 74 to 80, the court held that the Charter 31 was itself horizontally effective. So if interpretation wouldn't get you to the end, you could use the Charter. And they actually decided that in a linked case that isn't in the bundle on the same day, Stat, Wuppertal and Bauer, which is 2019 IRLR 148. So we got 3 Grand Chamber judgments on the same day, all echoing each other. So, my ladies, those are the cases. Can I summarise what we say the principles are emerging from them? Firstly, any practice which may potentially deter or is liable to deter a worker from taking leave is incompatible with Article 7. The question is not whether the individual worker is in fact deterred or prevented from taking annual leave. And not paying anything in respect of annual leave is the exemplar, paradigm, prototype, whatever word you want, of such a practice. It necessarily amounts to a potential deterrent. Secondly, it is not necessary for the worker to show he sought to take leave but was refused annual leave. In the words of A.G. Bow, approved by the Court of Justice in Kroiziger, it is irrelevant that no request is made to take annual leave. Thirdly, the only circumstances where a worker loses the entitlement to untaken Euro leave at the end of the leave year is where the employer can meet the burden of showing it, quote, specifically and transparently A, gave the worker the opportunity to take paid annual leave, B, encouraged the worker to take paid annual leave, and C, inform the worker that if he or she does not take the leave, the right will be lost at the end of the leave year. So fourthly, it follows if the worker has not taken all of 4 weeks leave in any leave year and the employer cannot meet that burden, the right does not lapse. Rather, it carries over and accumulates until termination. And on termination, the worker is therefore entitled to a payment in respect of the untaken leave based on the same amount as if he took the leave during employment. Which brings me to the tribunal decision, where it went wrong. So if I can just begin by setting the context to it, there were skeleton arguments exchanged before the tribunal. You can see the argument for the claimant at 245 in the supplemental bundle. And you can see at 1A Mr. Stevenson's arguments, referring to the Charter and the Working Time Regulations. 1A, the respondent failed to pay him the sum of sums due to him under Reg 14 and Reg 16 in respect of taken and accrued but untaken holiday. And amplifying that at 2, because at B, he talks about whether claimants for payment in respect of leave were time barred, and C, whether in light of SASH the claimant was entitled to payment on termination in lieu of untaken leave. So if I could summarise, Mr. Stevenson was effectively saying King applies to both untaken and taken but unpaid leave. But what he clearly was saying was there is a right here for untaken leave based on King. Now for the respondent's skeleton began at 266, and their argument was you had to show the worker was individually deterred. If you look at page 285, this is Mr. Smith's argument, paragraph 60.
Sorry. Oh, yeah, Mr. Smith. Sorry,
Mr. Smith. Yeah,
Yeah.
We've got two Kings and two
Yeah.
Smiths here. Which 60. His argument was that the King principle arises A, where the employer has failed to provide an adequate facility for the taking of paid annual leave, and B, as a consequence, the worker has in fact been deterred from taking their full entitlement. Well, that's wrong. That's wrong because of all the cases we've just seen. And he amplified that at 62 by reference to Harvey's, which used to be a respectable publication. Well, the trouble is it's a loose leaf, isn't it? It just gets added to, where Harvey says, after King if the employer refuses to allow a worker to take all of his or her annual leave, that's at paragraph 62.286, the right to take it can be carried forward. That, with respect to the learned author, is wrong. There's nothing about a refusal in King. And for what it's worth, that passage no longer appears in Harvey. But it was always wrong. And what we say happened then is the tribunal adopted the respondent's arguments. So if we can go to the, and those arguments were wrong. If we go to the tribunal decision in the core bundle, and begin at paragraph 9, this is under its findings of fact section. Thus, on the claimant's own pleadings of evidence, he took annual leave but was not paid for it. The respondent did not dispute that. It was not the claimant's case that he was deterred from taking annual leave because he knew that he was not going to be paid. That is a significant distinction in relation to the claimant's reliance on the case of King. Well, it isn't. He's identical to King. He's a fortiori to King because he now has Kroiziger and Shimizu behind him. So that's a bad start. We then come on to how it framed the issues for it at 17A at page 148. And you can see at A how the tribunal framed the question. Was the claimant at any time, this is page 148, 17A, was the claimant at any time denied the right to leave under regulations? Well, if you ask the wrong question, you're likely to get the wrong answer. But that is not the relevant question after King, Kroiziger.
Well, what do you say should have been asked?
Well, it should have said, has the claimant not taken leave in any leave year, up to less than his 4-week entitlement?
And or has he not been paid?
And or has he not been paid? I'm only talking about untaken this time. Has he not taken all of his euro entitlement? Question 1. Question 2, if so, has the respondent met the burden of Kroiziger? To which there can only be one answer. Because it would be a matter for the respondent to plead and lead evidence that it couldn't. How could it say it encouraged him to take leave when it denied he was a worker and didn't pay him? I mean, it's hopeless. So they were always going to lose. But now we see at 149 the wrong question feeding into the wrong analysis, because the tribunal at 19 refers halfway down to the statement of paragraph 40 of the claimant. That was the one where he said, I didn't take my leave full entitlement every year, which you might have thought leads us straight on to King and Kroiziger. But then says at the end, however, he gave not a single example of an occasion on which he had been denied the right.
Sorry, where are we?
End of 19.
Oh.
Irrelevant. And wrong question. Because Mr. Kroiziger, Mr. Shimizu, I'm getting my names muddled up, Mr. King, none of them could show they had ever been denied it. And as you'll remember, Mr. Shimizu was even invited to take it. The judge then summarises Mr. Stevenson's arguments, and at 24 refers to Mr. Stevenson's argument that the burden wasn't on the claimant to show he'd taken holiday, but on the respondent. And at 27, wrong analysis of King again, halfway down the paragraph at page 152, analyses King as it was concerned with leave that had accrued but was not taken because the lack of payment had dissuaded Mr. King from taking it. Wrong, wrong, wrong. And then the really critical paragraph, 28, having referred to the King case in the first two sentences, says it is the claimant's case that he had accrued leave but not taken it during his employment. If it is the claimant's case that he had accrued leave but not taken it during his employment, that case is unsustainable on the facts. Well, that's a clear misdirection. What it's saying is the only way you could have won this case was to show, both in your pleading and your witness evidence, that you had in fact individually been deterred. Next sentence, on the claimant's own evidence, he took leave in most, if not all, the years of his employment. Yes, and to the extent he didn't take the leave, Kroiziger and King. If it is Mr. Stevenson's submission that the lack of accurate records of the leave the claimant took means that I must assume that he did not take any or all the leave to which he is entitled, I disagree with that submission. That's wrong as well, because the claimant has given uncontested evidence that he did not take all of his entitlement in any leave year. And then said the claimant can't claim the benefit of the doubt and be treated as though he's not taken leave. Well, yes, he could, because Kroiziger says the burden is on the respondent. And this is, in our submission, important. The claimant's claim as pleaded and on the facts can only be a claim for holiday pay too. In other words, he has not pleaded, nor has he led factual evidence to the effect that he was positively refused request to take annual leave. All irrelevant. And then finally, if I'm not overdoing it, 31, paragraph, where the worker has taken leave and is seeking payment on termination under WTR, the claimant's position, he is not, in contrast to Mr. King, entitled to claim a single payment on termination as accrued over the years. Well, he is. He's in identical circumstances to Mr. King. Further down the paragraph, about 2/3 down, the fact remains that the claimant, unlike Mr. King, was not, on the facts of this case, dissuaded from taking leave. Wrong, wrong, wrong. It's potential deterrence, and the respondent hasn't met Kroiziger. And then the summary at 32, given the statements the claimant himself has made, and his failure to particularise, back to the pleading, any occasion on which he sought to take holiday and was prevented from doing so, any claims under Reg 13 and so on must fail. So there's the clearest statement at 32. Everything is wrong. So in summary, the tribunal asked itself the wrong question. Firstly, was he individually dissuaded from taking it? Probably because of how the respondent put its case. Secondly, it gave the wrong answer. It wrongly understood the principle in King. Thought the claimant had to show he was individually deterred from taking leave. Thirdly, the tribunal decision is even more wrong in the light of Kroiziger and Shimizu, because the employer had failed to meet the burden of proof on it. Fourthly, it wrongly decided that because in his pleading and witness statement he had not said he was prevented from taking leave, he fell outside King. He didn't. In relation at least to untaken leave, he fell squarely within it. So if I can quickly turn to the respondent's arguments. Now they are, firstly in its skeleton at paragraph 17.2, page 52L, where they say in relation to the King decision that it 17.2 has the effect that workers are permitted 17.2.1 to carry over without temporal limitation any Euro leave which they do not take during a particular year because of the employer's refusal. So they're still misinterpreting King. And they make no mention anywhere in this skeleton of Kroiziger or Shimizu.
Those cases had been decided by the time the EAT dealt with this appeal. Had they been decided by the time of the ET?
Yes, they have been. And in fact, Mr. Stevenson referred to Kroiziger and Bauer, two of the cases in his skeleton.
Yes, I saw Bauer, but Kroiziger as well. All right.
So no mention of Kroiziger and Shimizu, which are fatal to their argument. But then they say at 52U, at 45, if it really did shout out from King the claimant might have potential claims, then the claimant could and should have applied to amend his claim to include such a claim. But that wasn't the basis upon which the tribunal decided this case. It didn't say you haven't pleaded King at all. It decided it on the basis that Mr. Smith had not shown had not pleaded or shown he was positively deterred. They didn't say, well, it's because you haven't pleaded King or you haven't pleaded the Charter. They did no analysis whatsoever of that. They kicked out his claim based on King and untaken leave because he hadn't pleaded or led evidence that he was dissuaded or had a request refused. And finally, at 55, the respondent there seeks to challenge factually the evidence that the claimant had given, this is page 52W, the evidence the claimant had given to the effect that he hadn't taken his full leave every year. So they challenged the fact that he never took his full entitlement to leave under WTR, the WTO, or directive in any leave year. Well, with respect, that's hopeless, because his evidence was uncontested. And as my Lady Justice Simler said, this case has to be approached on the basis that you take the claimant's evidence at the highest. And his evidence, highest or lowest, was that I didn't take my leave every year. What is clear is that the employer can't meet the burden of Kroiziger and say he actually had the opportunity to take paid annual leave every year. So, my ladies, that in a sense is first ground of the appeal. we say there's only one, there's an ineluctable conclusion. I know Stephen Sedley likes those words. Is that the only possible result is that the claimant fell within the ambit of King and Kroiziger. But nevertheless, if you're with me, the case will still need to be remitted for the tribunal to decide exactly what dates he did or didn't take his leave. And that brings me on to ground B, which is the pleading issue. So this is the second issue the tribunal determined, beginning at paragraph 17b. Page 148. (17b). Did the claimant bring a claim under Regulation 14 WTR in respect of leave accrued but untaken in the final year of employment? And that's the question that they then address at paragraph 34 and following. Now, 4 preliminary points before I get on to the law. The first thing is that the tribunal here was only deciding that no claim could be taken for untaken leave due in the final year of employment. It wasn't considering the King claim because it had already decided King claim was barred. So it gave no consideration, for example, to what was the appropriate vehicle to a King claim, whether it should be done by amendment of Regulation 14 or direct reliance on the Charter. It wasn't addressing King and the pleading at all. All it was addressing was whether, as a matter of ordinary domestic law, claimant had a pleaded claim for a Regulation 14 claim. Secondly,
that would have been analogous to the holiday pay 1 claim.
Yes.
In King and Session.
Exactly, my lady. Secondly, it didn't engage in any analysis of the facts relevant to a Regulation 14 claim. For example, how much leave the claimant took in the final leave year. It decided it again as a preliminary pleading point. But thirdly, we say that given the tribunal rejected part of the claimant's case and said you didn't take any leave from the 1st of January onwards, so it rejected his evidence in the table, we say to adopt the metaphor of Lord Justice Bean in the Mervyn case, it then shouted out that he had a good potential Regulation 14 claim. Now, the reason, of course, the Regulation 14 claim mattered is that if there was a valid domestic Regulation 14 claim, it would be in time. There's no dispute about that. And you can see our skeleton at paragraph 53. I won't go to it, the details. It would be in time. Critically, though, he wouldn't then just have a claim for Regulation 14, which is important enough in itself. But if we're right on the series point, which I'll come to next, it could then be linked, we say, with past underpayments in respect of taken but unpaid leave. That's our ground D for the purpose of section 23. Now, the law, well, I can deal with this briefly, but it takes us to the House of Lords and Stringer. But I'm pleased to say I had the privilege of being led by Mr. Jeans. We then ended up against each other in Williams and today, but we were together on the House of Lords and Stringer. And it's at tab 25. So Stringer had been decided by the Court of Justice in relation to sick workers could carry over and accumulate, and it then came back to the House of Lords to decide the wages point. For what it's worth, it was a Reg 14 claim. The very claim at issue in Stringer was a Reg 14 claim, and I think it was £16.42. That was the sum at stake, but it obviously had important implications generally. So the House of Lords decided it, because these Regulation 14 claims are almost brought daily in the tribunal. And so the sole issue was, did a Reg 14 claim fall within the scope of wages in Section 27 of ERA? And the House of Lords unanimously said it did. If I can pick up first Lord Roger at paragraph 16. That's setting out the relevant claim here for Mr. Ainsworth. I call it Stringer. There was some technical reason why it's called Stringer, even though the claimant was Ainsworth, which I forget what it is. All I know, it meant the House of Lords initially rejected our application for permission to appeal in that it was in the wrong name. But anyway, it was for Mr. Ainsworth. And you can see that he hadn't taken any leave during a very small period of 4 days, and his claim was brought for a Regulation 14 payment. And the three speeches were given by Lord Roger, Lord Newburger and Lord Walker, and at 24 to 25 in Lord Roger's speech. Well, perhaps I can pick it up earlier just to avoid repeating myself when we come to the next ground of appeal. One of the reasons at paragraph 21 the House of Lords decided to hear the point that the point wasn't academic is you can see explained at D downwards, paragraph 21 from D downwards, that the point that Mr. Jeans made was that unless you could bring a claim under Section 23 and link it as a series, you would have to keep making successive applications to the Employment Tribunal. The claimants were incurring unnecessary expense, and the tribunal system was being cluttered up with unnecessary applications. So that was the practical background here, and we say that remains relevant to the next ground of appeal I'll deal with. And so they decided the point wasn't academic because it had that practical importance. And Lord Roger, first of all, decided at paragraph 24 at G to H that a payment under Regulation 16, that is payment for leave taken during employment, is part of the consideration which the employee receives in return for the work done or to be done, and therefore falls within wages. And then at 25 dealt with Regulation 14, saying, well, first it's slightly different, it's called payment in lieu, but he'd cited from the Court of Justice in Stringer, saying the purpose of the payment in lieu was exactly the same as the purpose of payment during employment. The purpose of the payment in lieu was so the worker could have a period of rest and leisure after employment ended. And goes on to conclude at C to D, so even though he receives it only when his employment has been terminated, just like any other final payment of wages, it is part of the consideration for the services which he has previously performed. So it was just like a Reg 16 payment, and both were wages. And he confirmed that at paragraph 29, but I'll leave that for your own note. The other, I won't go to the other speeches, but I can give you the references. It's Neuberger at 69 to 70, and Lord Walker at 56. And Lord Hope and Brown agreed with all three. So it was unanimous House of Lords that a Reg 14 payment can be brought as a deduction from wages. And there's one other point that's worth noting because it is relevant, it might be relevant to the pleading issue, and it's at paragraph 58 in Lord Walker's speech. In relation to equivalence, as you know, we're not pursuing equivalence, but this is just relevant to when tribunals should allow points to be taken on community law. So Mr. Jeans asked leave to rely on a point of community law not taken below. That is equivalence. I think we had a disagreement about how good the point was, but anyway, he was right and I was wrong. We hadn't pleaded it below, it hadn't been taken below at any stage. And you can see at 58, national courts are required to consider relevant issues of community law, even if not raised at the right time by the parties. And Peterbrook. So they allowed the point to be taken. So that's the background, the legal background, and then we come back to the tribunal decision. At give me one moment, page page 155. So at paragraph 34, they talk about the formula. They referred to the respondent's draft list of issues. I'll only go to these quickly because, as we know, they weren't agreed. At paragraph 35, that's at page 348 for your note. And you can see the respondent's proposed list of issues at 348 in the supplemental bundle. Beginning at 348, and it's really paragraph 12, where you can see how the respondent framed the issue. Is the claimant entitled to holiday pay under Regulation 30 of the Working Time Regulations, and if so, how much? So nothing to suggest it was restricted to Reg 16, just a general issue of whether he was entitled to holiday pay. And the tribunal at paragraph 38 referred to the claimant's third list of issues at 213. Apologies, these jump around. That's the relevant document. Where you can see under D at 213, the claimant was listing unauthorised deductions by failing to pay holiday pay. (1.2F), or 1.2E, I should say, over the page at 214. The claimant says he is entitled to a minimum of 5.6 weeks per year up to termination date, and claimed holiday pay as part of his entitlement to wages, and then gave a table at 215 where you can see in respect to the final leave year under 7 they'd actually put 5.6 weeks pro rata. Now I asked rhetorically, what could that mean other than a potential claim under Regulation 14? And going back to the tribunal, we say the key error of law in this in relation to this issue is at paragraph 40.
Paragraph
40 at page 156. It first of all refers to the list of issues that I've just taken my ladies to, but then decides the more important matter is the claim is, more important in my view, was the claim that was originally pleaded, no application to amend the claim having been made, and refers to paragraph 37. If my ladies recall, that's the paragraph I showed you at the outset under the heading unlawful deduction from wages. That paragraph appears under the heading unlawful deduction from wages and makes no reference to WTR at all. If one keeps a finger in there and goes back to paragraph 37, which is at page 185, as an employee or worker, respondent failed to allow my entitlement to paid holidays from the outset of my employment or at a later stage. Well, it's pretty clear what it was referring to when you read it in context. And that was a continuous failing up to the date of termination. It was obviously referring to working time. And then going back to 40, the tribunal says that paragraph appears under the heading unlawful deduction from... Sorry, I've already read that. In my oral decision on this point, I took the view that it was not possible to construe, those are the critical words, not possible to construe that paragraph as a claim under Regulation 14 and 31B. Particularly as the claimant was legally represented at the time the claim was submitted. Well, in our respectful submission, that's just plain wrong, because it's wrong in light of Stringer. Of course you can construe paragraph 37 as embracing a Regulation 14 claim.
Because the source of the obligation to make those payments is the directive implemented by the WTR.
Yes.
And there isn't, I mean, the wages claim is a vehicle for enforcing those rights.
Yes, yes. And it says failed to allow my entitlement. I mean, that's perfectly apt to capture a Regulation 14 claim. So that sentence is wrong. And then they go on, the tribunal judge goes on at the end of 40, this paragraph is plainly, in my view, a claim for holiday pay advance as a claim for unlawful deduction of wages only. Well, you're looking quizzical, my lady Justice King.
Sorry about that.
But it is wrong,
Does it
isn't
mean-
it?
Yeah, well,
We'll hear what Mr. Jean says. But
I've yet to hear the response to that.
yes, I know. We've all seen how things can change. But that is wrong in my respectful submission.
Well, is it wrong or is it meaningless?
Well,
Sorry. I mean, what does it mean?
I think it amplifies the point that's gone before. You've brought this as an unlawful deductions claim, so you can't use it as a vehicle, to echo what my lady,
Yes.
Lady Justice Elisabeth Laing has just said, to bring a Regulation 14 claim. Whereas, of course, you can.
So the tribunal somehow making a distinction between a claim brought under the WTR and labelled as such, and a claim brought to enforce the directive, which is advanced under as a claim for unlawful deduction of wages.
Yeah. Well, it gets worse than that, because the tribunal allows the claim to be brought for Regulation 16. It allows the claim to be brought for Regulation 16, even though that's not referred to. But it does that when it comes to dealing at paragraphs 45 and onwards. But it concludes that claim is out of time. You can see that, for example, at the end of 46. The entire claim under Regulation 16.1 and 31B was therefore presented outside the statutory time limit. So it does allow a claim to Regulation 16 to be advanced, despite the fact there's no reference to Regulation 16 in paragraph 37. But yet, it doesn't allow a claim for Regulation 14 to be advanced under the same domestic vehicle. And with all respect to the judge, we say that any tribunal knows, or almost anyone, that a claim for unlawful deduction from wages can embrace Regulation 14 and Regulation 16. It's quite common for the claim only to be advanced as unlawful deduction from wages. So we'd say that's where the tribunal's gone wrong in that. And we also say at 42, where it said it was incumbent on the claimant who had the benefit of legal representation throughout the case to plead his claim clearly and unambiguously by reference to the statutory provisions on which he relied. Well, he had done. He said, I'm relying on Section 23. I told you about, he doesn't need to mention Regulation 14. He doesn't need to mention Regulation 16. So we say the tribunal's wrong on this as well. But can I just show you one document before I quickly move on to the respondent's arguments? It's in the supplementary bundle at page 340. Because one of the points made by the respondent is we weren't on notice that you were ever intending a Reg 14 claim. And it's a letter, page 340, written by my instructing solicitor. In 2012, and you can see at 341, unambiguously, she was saying that following this was at the stage when we hadn't yet got to the Supreme Court, as the employment judge Corrigan has concluded the claimant is a worker, he is entitled to compensation for accrued but untaken holiday pay at the date of termination. He was never paid holiday pay and seeks compensation for unlawful deductions. And then goes on to say, we expect the respondent to dispute every single issue. Well, that was maybe prescient. But if they are disputed, they should be discussed at the CMD. So they had notice from them that he was claiming a Regulation 14 claim.
And was that dealt with at the CMD, or don't we know?
I don't think it was, no. I think it was left there. So turning very briefly to the respondents' arguments in their skeleton, they say firstly at paragraph 44, this is page 52T, well, it's 43 and 44. Firstly, they say, well, the claimant had to apply to amend if he was to run a claim based on Regulation 14. Well, we say it begs the question. We say he didn't need to apply to amend. Secondly, at 46, they say this is not a case in which there was any doubt or secrecy about the respondent's view of the claimant's pleaded case. Well, so far as we know, there was no response to that letter I've just shown you. And the first time the respondent started complaining that you needed permission to bring a Regulation 14 claim was in the skeleton arguments before this hearing, before E.J. Morton. Thirdly, at 47, it is said, well, you have to take a point below. Well, this isn't about pleading. This point was taken below because before the tribunal, Mr. Stevenson said, yes, I am seeking to rely on Regulation 14. Both in his skeleton, I'll give you the page reference 245, and in his submissions to the tribunal. I mean, it's obvious because the tribunal, the point was contested. So, my ladies, those are my submissions on Regulation 14. Insofar as Mr. Jeans relies on saying, well, you can't bring a Regulation 14 claim based on King, we'd say exactly the same. First of all, the tribunal didn't decide the King point on that basis. But if it did, its analysis was infected by the same legal error, because a King claim can also be brought under Regulation 14 via mar leasing, and it is for liquidated sums due on termination, which therefore fall within the Wages Act jurisdiction. So that's the, unless there's anything I can add, either of my ladies wish me to add. Well, then I can turn to the series point, which is ground D of the appeal. And as I've already explained, that if the Court of Appeal upholds the pleading appeal on Regulation 14, then there's a potential linkage back as a series. And I should say this is a point of some general importance, because it's arising obviously in other claims, not just in the holiday pay context, but also in relation, for example, to the national minimum wage.
There is a way in which this ground could be academic.
Yes.
But you're saying we should decide it in any event.
Yes. Yes, it could be academic if you're against us on the Reg 14 point and say, well, there's nothing in time.
But
there's nothing.
If we're with you on ground A,
yes,
then it might be academic as well.
It might be, yes. But I would still ask that the court deals with it, because I know that some cases have been stayed in tribunals, and I heard of one stayed in the AT as well, because of this point. Because effectively everyone's been log jammed because they've got Agnew.
But and Agnew was settled before the Supreme Court decided
Exactly.
whether to
Agnew was
hear
listed for hearing in the Supreme Court. In fact, I was going to intervene on behalf of Unison, and then the parties went into mediation. I don't know if it's actually settled.
Right.
But whatever it is, it's come out of the list, and it's presumably not going back in for many years.
I understand that it may in fact not have settled.
Why am I not surprised?
But it's certainly out of the list.
Yeah.
And it may be one of those cases where the devil was in the detail. They thought they had the basis of a deal, and they may not have done. But
Okay.
I'm not sure I can say any more about that. I had some discussions with counsel who were
Thank you, that's most helpful.
Oh, thank you for that. Yeah, so we would say it's obviously a point of general public importance. It's a bit like the Ainsworth point. What you do about a series. Because at the moment, the EAT is consistently saying, well, we're bound by Bear Scotland and not the Northern Ireland Court of Appeal. So until you get to the Court of Appeal. So can I first of all say what isn't in dispute? It's not in dispute that the claimant wasn't paid when he took leave, of course. There's no dispute that such a complaint could be brought under Section 23 during employment. And there's no dispute that if he could bring a Regulation 14 claim and wasn't barred as a matter of pleading, that would be in time. So that brings us on to Bear Scotland. Now the tribunal dealt with this issue briefly at paragraph 60.
There's also no dispute that the reason he wasn't paid is because the respondent took the view that he wasn't entitled to pay.
Yes. And the tribunal dealt with it at paragraph 60 onwards. Well, I'm not going to really waste time going to the tribunal because all the tribunal said was we're bound by Bear Scotland. So it takes us. But there is one point that it's important to note the tribunal got wrong. It's at 60. It said at the end of, this is at page 164, section 2348 era would also have prevented him recovering any payment where the date of payment fell more than 2 years before 1st August 2011.
Sorry, which paragraph were you reading?
Paragraph 60,
60.
164, the last sentence. Now that's wrong, and it does have some importance, because if the court looks at the authorities bundle, tab 6A, it's at page 79. This is the statutory instrument which brought into effect 23.4a or introduced 23.4a. And you can see over the page at 2 the amendment. So an amendment was introduced limiting the period of recovery 2 years. Now the reason why that's relevant is we say, well, when Parliament wants to limit recovery, it does so expressly. Well, Parliament or the legislator, it's a statutory instrument. But you can see under 4, the amendment made by Regulation 2 only applies in relation to complaints presented to an employment tribunal on or after 1st July 2015. So it didn't apply to Mr. Smith's case. But it will apply going forward. So going forward, a series is capped at 2 years, or rather from the 1st of July it is. But at the time of Mr. Smith's claim, because one tends to forget this was now 10 years ago, he wasn't subject to the cap. So we then come to the word series in 23.4 of the Wages Act. Now, I'll just say briefly about the legislative history. There's a long, long history to the provisions protecting workers against deduction from wages, dating back to the earliest, to the Truck Acts, which we have in the bundle, and I will come to very briefly in due course. But the 1996 Act was a consolidating act, and it did adopt some change of wording, but it consolidated the provisions formerly found in the Wages Act 1986, and that's divided 2. Of your bundle, and you will see that the short title of the Act at page 22 was Protection of Workers. I appreciate this may be obvious, but it's just setting the scene of what we say was the purpose of this legislation. And over the page at 24. An act to make fresh provision with respect to the protection of workers, and to that end it laid down the various duties which are now found in ERA and which I'll come to shortly. And it repealed the existing legislation. You can see that at 36.
such as the Truck Act 1831 and the Truck Act 1896, which are still in force. I've checked all of that legislation, and there was a limitation provision in one of the acts, and that was the Truck Act 1896. Most of these gave rise to criminal offences. In fact, some of the early legislation was enforced by the Factory Inspectorate. But at page 18, the Truck Act 1896 had a longer limitation period of 6 months from the date of deduction. That's section 5. Whereas the 1986 Act introduced a shorter provision of 3 months. But to foreshadow our point, we say one of the compensatory measures for that was series. So you had a very short limitation period, but the compensatory measure was series. And that leads me on to the legislation itself, and I'll only go through this quickly, but just to emphasise that this legislation isn't just about deduction from wages in the way the tribunals often understand it. So if one goes to divider 4, which is the provisions now in part 2 of ERA, we say you read across the same protective purpose from the 1986 Act, because it's a consolidation act and therefore it's not affecting any material change. And just to give a quick tour through these, firstly, 13 is protecting people against unauthorised deductions, unless there's authorisation in contract or by written agreement. That's 13.1a. And you can see 13.3, the wording is wide, that it applies if there's a deduction on any occasion. And 13.6, the relevant agreement has to be in place before the deduction is made. So all protection. There's some exemptions in section 14, for example, industrial action and check-off, which I needn't go to. Section 15, again, emphasising the protective nature of this legislation, that it also protects where employers require workers to make payments to them. So an employer can't get round the deductions legislation by saying, well, you've got to make me payments, and then that's not a deduction. Because under 15.1, an employer shall not receive a payment from a worker, and it's subject to the same conditions unless it's subject to written authorisation. And again, it's not retrospective, 15.4. Section 17, and in my submission these are important, specific provisions are put in place to protect workers in retail employment. Because a particular concern of the past, of the legislation in the past, have been people in retail employment having their wages deducted because of stock shortages. And you can see at 17.1 it refers to cash shortages or stock deficiencies, and then defines retail in employment. And so these are the categories of protection in this section, and it's important to note section 17.4, it included where the employer deducted cash shortages or stock deficiency, where it alleged it was a result of dishonesty or conduct on the part of the worker. So once more, we say that all fits the same theme: protection, protection, protection. An employer can't just say, well, we deducted it because we suspect you were dishonest or it was your conduct. No, the worker is protected. And that feeds into section 18, where you can see you can't have a deduction from a worker in retail employment that's greater than 1/10 of the gross amount of wages. So it limits substantively the amount that can be deducted. And also it limits the period during which the deduction can be made. It can't be made more than 12 months from when the employer established the deficiency. Section 19 is another anti-avoidance one. An employer cannot define wages to say, well, your wages you're entitled to receive means only your wages after deficiencies and cash shortages have been taken into account. So it's an anti-avoidance provision again. Section 20 at page 48 puts in place parallel protections for retail workers in retail employment where they receive payments, where they're required to make payments. They again can only be made in a 12-month period, that's 23. And they again at 21 are limited to 1/10 of the gross amount of wages. So important protections for what we submit are vulnerable workers going far beyond simple deductions in the tribunal. And it's against that background that section 23 we say falls to be considered. Because this is the relevant provision that's at issue here. If one looks at 23.1, you can see 23.1a applies to ordinary deductions. 23.1b applies to payments, section 15, ordinary payments. And then the C and D are the ones for retail workers. So all these complaints are brought to the tribunal via the vehicle of section 23. And by 23.2, you then get the period of 3 months, beginning with, in the case of a deduction, the date of the payment of wages from which it was deducted, and in the case of a complaint relating to a payment, the date when the payment was received. And then the words "a series." So, to foreshadow the point I've made already, we say, consistent with the protective purpose, the mitigating measure for the short limitation period is the series provision. And we say it's an ordinary word and it should not be construed restrictively given the protective purpose of the legislation. So that brings me on to the two authorities. So firstly, Bear Scotland. It's at tab 79. Sorry.
That sounds wrong.
It's not at tab 79. It's at page 649. It's a relevant passage.
In short, the approach in Bear Scotland, maybe I'm anticipating what you're going to say, is to read in the 3 months, which is expressly mentioned in section 23, subsection 2, into subsection 3a, where it isn't mentioned.
Yes. And we would say that that sort of exercise in strained construction, if I can call it that, is permissible when you're doing so to fulfil the, may be permissible when you're doing so to fulfil the purpose of legislation, but not in this context. And at 79, you can see that Mr. Justice Langstaff begins by saying series is an ordinary word.
So paragraph
79, bottom of page 649.
Thank you.
You need two things: sufficient similarity of subject matter, and secondly, temporal repetition. Well, we say if he'd stopped there, that would have been fine. We say, yes, that's right, it's an ordinary word. It just means things of the kind that occur across time. That's what series means. But then, we say he then goes wrong for reasons which already been summarised to me by my Lady Justice Elisabeth Laing. That he says he accepts Ms. Rose's submission has to be taken in context. That is one in which a period of any more than 3 months is generally to be regarded as waiting too long to make a claim. Well, I'll show you the Arthur case in a minute, where Lord Justice Mummery says exactly the opposite. He says, well, the purpose of this legislation is so you don't have to rush off to a tribunal the first time things go wrong. Then he says, I doubt the draftsman had in mind. Now notice this is no reference to purpose, that a deduction separated by a year from a second deduction of the same kind would satisfy the temporal link. Well, we say, why not? I mean, if you every single year your Christmas bonus isn't paid to you, every single year, that's a series on anyone's, on an ordinary conception of the term. So, and then at 81, he goes on to talk about the sense of the legislation, and saying, I consider that Parliament did not intend that jurisdiction could be regained simply because a later non-payment occurring more than 3 months later could be characterised as having such similar features that it formed part of the same series. The sense of the legislation is that any series punctuated from the next by a gap of more than 3 months is one in respect of which the passage of time is extinguished. Well, we'd say that's not legitimate statutory interpretation. You interpret by the ordinary words in accordance with the purpose. We endorse what my Lady Justice Elisabeth Laing has just said. He's reading a subclause into the legislation which isn't consistent with the purpose. In fact, it's inconsistent with it.
I mean, it might be thought there's a distinction in the section between one-off infringements and patterns of infringement.
Yes. But nothing to suggest you can read in those words into the legislation. So we say, with respect, Mr. Justice Langstaff has not applied the proper principles on statutory interpretation. And we say the Agnew decision is correct. It's at tab 46. And the issue here at page 9112 for the Northern Ireland Court of Appeal is at C. (10C) at 9112. It was analysing whether a series deduction in Article 55.3 of the ERO, which is the, you can see at 4, the Employment Rights Northern Ireland Order 1996. We have got copies here if my ladies wish them, but if not, you can take it from me. It's in identical terms to the Wages Act jurisdiction, including the protections against retail workers and so on. And Lord Justice Stevens analyses this at paragraphs 93 and following. And particularly, if I can leave the court to look at 93 for itself, it's at 99 and following that we say is the correct analysis. Whether there's been a series of deductions is a question of fact. You can have deductions occurring at different time intervals, 100. There is nothing in ERO to suggests they have to be contiguous, which we again say yes. And they said that you need to identify something that links them as a kind, and that's in this case because they're all unlawful deductions in relation to holiday pay. At 103, we agree there has to be sufficient similarity of subject matter. That was the opening paragraph of the judgment of the relevant paragraph of Mr. Justice Langstaff in Bear, Scotland. But here, everything is linked because they're all in respect of holiday pay. Each unlawful deduction is factually linked to its predecessor by the common fault or unifying or central vice that holiday pay was calculated by reference to basic pay rather than normal pay. And they go on to refer at 105 to arbitrary results, which can result if you adopt any other interpretation, because it becomes a matter of chance whether or not there's a 3-month gap or not. Someone who takes leave very frequently across the leave year in short bursts can potentially recover. Someone else who doesn't won't. Someone who has a period of other forms of leave, such as maternity leave or parental leave or something, will obviously see the gap. So, against that background, if I can briefly deal with our 6 submissions on interpretation. Firstly, we say, well, you start with the ordinary linguistic meaning of the words. And if one looks at the Arthur case, which is at tab 23, now this is in analogue legislation because this is in whistleblowing legislation, which allows a linkage back across time where you have a series of similar acts. The relevant acts here were at paragraph 9.301, by various acts of victimisation because of whistleblowing involving about 12 different people. And the Court of Lord Justice Mummery sets out at section 48.3 the relevant provision relating to whistleblowing, a series of similar acts or failures. Well, if anything, that's narrow wording because our legislation just uses series. It's paragraph 14. And Lord Justice Mummery addresses series of similar acts at 26 and following. Where he says you have to look at the natural and ordinary meaning of the words, having regarded to the context, the overall time limit, their evident aim and the overall purpose. We say that's correct, but that's what Mr. Justice Langstaff didn't do. And he then at 29 talks about why Parliament has made exceptions to the short 3-month period where you don't have isolated acts. And we place particular emphasis at the words, his words from A to B. A vulnerable employee may, for understandable reasons, put up with less favourable treatment or detriment for a long time before making a complaint. It is not always reasonable to expect an employee to take his employer to the tribunal at the first opportunity. So we say that's a better indication of the purpose behind series in that legislation and this. And then goes on to say you may have B to C onwards. There may be between isolated or discrete acts a common or connecting factor. So echoing the idea of payments that are similar in kind.
And then there's a reference to deductions. At the end of the paragraph.
No, I think I think that was an argument that the employee had been victimised by a deduction. I don't think a specific complaint was brought as a deduction.
No, but
Sorry, yes, I see.
I think the point he's making is
Yes.
that if you have regular deductions, they could be a series.
Yes, yes, I apologise. You're right and I'm wrong. And yes, so again, a good example. And we say that's much more consistent with the purpose. And likewise at 31, that they can therefore cover a case, whereas here the complaint alleges a number of acts or detriments, some inside and some out. You just need some sort of connection. That's what he's saying. Something that makes it just and reasonable to link them. Some relevant connection is the test he adopts. And he says at 35, I won't read it, but you need to look at all the circumstances surrounding the acts to see if there is some link between them. And we say that's the proper approach, not to read in a 3-month gap. And that you see the same, I'll just give you the references in the judgment of Lord Justice Sedley at 41. And likewise, Lord Justice Lloyd at 45. So it's a question of fact and degree where you're looking at some something of the same kind. Secondly, we say that where the legislation intends to restrict the period of recovery, it does do so expressly, as it has done now by the deduction from wages limitation regulations. Thirdly, we say Bear Scotland ignored the purpose of Part 2. The purpose of ERA is worker protection. I've already shown you the Wages Act 1986. In the interest of time, my ladies, can I ask the court to read the reference to the Williams and North Navigation Collieries case, which is at tab 10, page 105, which is Lord Atkinson, saying that the purpose of the Truck Act 1831 was worker protection. So, you know, there's nothing new under the sun. There was a purposive approach being taken then. And we've also given the references to Uber, the more recent case, where Lord Leggett, at 70 and 71, talks about the modern statutory approach to purpose and the purpose of this legislation being to protect workers. And we say Mr. Justice Langstaff's interpretation detracts from the purpose. It's not restricted to holiday pay cases. It applies to all deductions caught by the Part 2. So a retail worker who puts up with some deduction from cash shortages for a bit can risk losing the right ever to be able to recover for them once 3 months have elapsed. Don't want to be accused of making jury points, but those who are not paid the national minimum wage, but where there's a more than 3-month gap, will lose the right forever to bring the claim in the tribunal to recover. It allows gaming by employers. For example, in relation to cash shortages, they can ensure that deductions only take place at 3-month intervals. And we say it leads to an unjust enrichment of the employer at the cost of the worker. And it's particularly pernicious now because, of course, you have the 2-year cap in 23(4)(a). So there's a double penalty. Fourthly, I know time's nearly up my ladies, but I'm nearly there. What would you like me to do? Can I do one last bit of toadying before lunch?
Why not?
The
Shame to break the habit of a morning.
well, we say, and this is where we need to look at the duty case, tab 38.
Thank you.
We say there's no sense of the legislation that the gap of 3 months breaks the series. Rather, it mitigates the harshness of the very short limitation period. And this is the duty case, which is a decision of my Lady Justice Simler. I think sitting alone.
No.
No, sitting with members. Apologise. We're at 30.
So what was your proposition? No sense that it...
The series mitigates the harshness of a very short limitation period.
Well, in the interpretation, yes.
Yes.
Sorry.
And this was another case on whistleblowing, dealt with by the EAT, presided over, as I've said, by Lady Justice Simler. You can see at 34 at 1707, the EAT set out the Arthur case. This was again on whistleblowing on series.
Which tab are you reading on?
Tab 38, page 707. And my ladies, the EAT there endorsed at the end of that paragraph, a series of disparate acts that are apparently unconnected may be treated as similar as forming part of a series where the evidence establishes a connection between them. Connection of fact and degree. And the EAT also said at 42, the point I've just made, the harshness of the strict 3-month limitation period is mitigated by section. So we say, contrary to Mr. Justice Langstaff, it's precisely because the limitation period is so short, and precisely because you don't want workers rushing off to the tribunal, that to protect them, you have this series provision.
And we have to construe the section as it now is with the addition of subsection 4 capital A.
And 45 as well. Again, emphasising it's a question of fact and degree. There's no bright line rules here. But there's certainly not a bright line rule that a 3-month gap breaks it. My ladies, I'm not quite finished, but I think I'll only need 10 minutes. Shall I break now?
Certainly. Very well, thank you very much. 2 o'clock, please.